To all present here today. It gives me immense pleasure to welcome you all to the second day of the International Research Conference on Insolvency and Bankruptcy, a joint initiative of IIM Ahmedabad and IBBI. On behalf of the IBBI family, I extend a warm welcome to our esteemed guests for today. Dr. Deepti Mukesh, Honorable Member, National Company Law Tribunal, Ahmedabad. Dr. T.K. Vishwanathan, former Secretary General, Lok Sabha. Professor T.T. Ram Mohan, Member, Economic Advisory Council to the Prime Minister. Dr. Navrang Saini, former Chairperson and whole-time member, IBBI. Shri A. Unnikrishnan, Legal Advisor, RBI. Shri Bhairam Vakil, Partner, AZB Partners. Shri J. Swaminathan, MD, State Bank of India. Shri Sumant Batra, President of SIPI. Professor Laura Cordes, Associate Professor of Law, Sandra Day O'Connor College of Law. Professor Sankeb Mohapatra, Professor Abhimandas, Professor M.P. Ram Mohan, Shri Sudhakar Shukla, whole-time member IBBI, other members of the governing board of IBBI, audience present here today, and stakeholders who have joined us online. Before we begin today's agenda of the conference, I would like to quickly give a recap of day one of the conference. It was inaugurated by Shri Rao Inderjeet Singh, the Honorable Minister of State for Corporate Affairs. In his inaugural address, he cited that the code has assumed larger significance post the COVID-19 pandemic and has been instrumental in saving both lives and livelihoods. The inauguration session was followed by a panel discussion on the theme Banking and Industry Perspective on IBC. This was followed by thought-provoking paper presentations by a myriad of researchers, professionals, and policymakers. Day one of the conference concluded with a workshop on data-driven insolvency research by IBBI and a special address on the topic Insolvency and Digital Economy. We are immensely grateful to all the speakers and participants for their enthusiastic participation in yesterday's discussions, and we hope that the same will continue today as well. Without further ado, we will now proceed with the first panel discussion on the theme Reforms in Insolvency Regime. The panel discussion will be chaired by Dr. Deepti Mukesh and moderated by Shri Suman Batra. We may begin with the discussion.
Thank you so much. A very good morning to all of you. It's such a pleasure to see such a full hall on a Sunday morning, something which I can assure you is not very usual in Delhi, where I come from. It's hard to get people out of bed on a Sunday morning. So thank you so much for attending. We really appreciate it. The topic for the session is reforms and insolvency. We wouldn't really want to delve into what has already taken place in the last nearly 5 years of insolvency reforms. History speaks for itself. You're familiar. We have discussed it threadbare over the last 4 to 5 years. The need for reforms, the reforms that have been undertaken by the government by way of legislative amendments as well as regulations that have been amended. But at the same point of time, those are what we call them as rear view vision. And in order for you to drive ahead, you always have to have one eye on the rear view. And that's how it really works, because that gives you a very good perspective of the law, of how we have implemented it in the past, and how we continue to look at it going forward. And therefore, in that context, as all of us share our experience, our views, our perspective with you, we will continue to reflect on the past as well. But I think, and I gather, and I take the liberty of saying this as something which I think all of us on the panel concur, that this is something which is more as a futuristic, more as ideas, brainstorming, our perspective, which we hope and expect would benefit the policymakers, the market, in terms of addressing and the issues that we continue to be confronted with in terms of making the IBC more efficient and be, if I may say, enforceable at the optimum level. Before I start with panel discussion per se, I'd like to request Dr. DP Mukesh just to make some opening comments as chairperson of this panel. And then we will move on to the question and answer sessions. We've attempted to start dot on time, and I assure you that we'll try and end up also around the same time. Thank you so much, ma'am.
Thank you, Mr. Batra. A very good morning, Sunday good morning to all of you. In a scorching heat, you all have come here to attend and share our ideas. So that's a very welcome step. Rightly, Mr. Batra said that we have already started or we have initiated the reforms in insolvency, because if you see, the prior to code, there were only two laws regarding to insolvency. One was Presidency Town Insolvency Act, and the other one was Provincial Insolvency Act. And as per our experience, because being at bar, I can assure that prior to code coming into force, most of the people, even business class people, they were unaware about the term insolvency or bankruptcy, or maybe very rarely, even in the practice, there was not much of emphasis on insolvency practice. Today, it has become a very upcoming branch of practice, not only for the lawyers, but also for the chartered accountants, company secretaries, and the whole idea about insolvency, what it is, how it is to be practiced, how it is to be resolved, and how we can help the business class or the entrepreneurs to not to go towards insolvency, but do a better business or ease of business. I think that idea has come, and the people in general, I would say, have come to understand the meaning of insolvency and consequences of insolvency, which is a very big reform, according to me. Last 7 years, probably every newspaper, maybe every alternate day, some news about insolvency or bankruptcy, some code, some changes, amendments. I think if Mr. Batra will agree with me that maximum number of amendments in such a short span maybe is witnessed by the insolvency code, and the demands and the litigations and the question of laws which have raised by the various litigants, the interested parties, the common person coming for the rights, financial creditors, everyone, is amazing. So the reform has already started, and we are on the path of it. And while discussing, we will come to know that how we can take it further. So probably we can start.
Thank you so much, Dr. Dipti Mukesh. One thing just I wanted to mention before I move on to the discussion was that I was supposed to be a panelist, but I think IBBA realized that having a lawyer on the panel is very dangerous because they would just monopolize one part with the microphone at all. So therefore, I got a message from Ritesh, sir, would you please moderate it? That was a very clever way of telling that please give opportunity to everyone and not just keep the mic to yourself. But that's on the lighter side. I mean, you all know lawyers can still continue to monopolize, whether as a moderator or as a panelist. But that was on the lighter side. Thank you so much, Dr. Deepti Mukesh, for your opening comments. Yes, of course, I think no law, at least as much as my knowledge goes, in the history of this country or the legislative reforms history of this country have witnessed that kind of backing at the political will in making the law functional, implemented with that kind of might being put behind it as IBC has seen. It's just phenomenal. And it's reflected not just in the acts of various amendments that have taken place, it's also how the stakeholders were brought together, how a narrative was built in the market that this is good, how the banks who were so, if I may say, the financial institutions of banks who were so disenchanted from the experiences of SICA and were completely disillusioned, were brought to try and experiment IBC and have shown tremendous amount of faith and continue to use it and have, of course, also benefited with it. But there is also some disillusionment which continues to exist, and we'll discuss those also. And those offer opportunities to reforms. As you all know, that every crisis, every problem offers a solution in itself, which is for the betterment. And that, in fact, leads us to one of the most, if I may say, debatable issue that continues to still haunt the market. What is the real purpose of the IBC? While the jurisprudence, the preamble, very clearly articulates that the law is meant to resolve a distressed enterprise. It is meant to find a turnaround for an enterprise by way of collective creditors mechanism. Yet, there is a shadow of doubt which continues to haunt IBC, because the narrative, which seems to be still very, if I may say, prominent in the whole discussion around IBC, is that the banks still view it from the prism of recovery. And their entire focus, attention, and even the decision making is driven by the fact that how can they maximize their own recovery rather than focus at the long-term turnaround of the enterprise, which is not just financial restructuring, but also involves operational restructuring, business restructuring, and also management restructuring, to ensure that the enterprise doesn't end up at the doorsteps of NCLT again in the near future. So, and Mr. Swaminathan, I mean, you know that this is something which is a finger pointed at the banks. Often observations that fall from the NCLT benches as well. How do you respond to that?
Thank you. Good morning once again to all of you, the Honorable Chair, the panel members, and the distinguished audience. It's a privilege to be here, and I must thank IBBI and IMA for this wonderful opportunity. And it's really, really heartening to see not just the seniors, but also so many youngsters participating in an event like this yesterday, and as well as on a Sunday like this today. And the number of papers that are being presented shows the interest that is being shown, as rightly said by the Honorable Chair as well, in this branch of law today, because that in itself shows the future, what the future holds for a legislation like this. So thank you very much for being here, and then thanks again for this opportunity. I wish Mr. Batra was there yesterday also, because today what he was alluding to in his opening remarks prior to passing the mic to me is that there is a general narrative that the bankers are seeing this as a tool for recovery. But yesterday, if you were there, you would be hearing the other side of the story, in the sense that the bankers are not bothered about the recovery. They are accepting huge haircuts in the 90s, nothing less than that. So what the bankers are doing. So the bankers are in a very, very catch-22 situation, that you are damned if you do it, you will be damned if you don't, is where we are. But in any case, having said that, I think this kind of situation is not new to us, because we know that we are an important part of the economy as such. So we have got to take this in the larger perspective. But coming to IBC as such, as all of us know, that the basic premise of legislation like IBC is resolution. I did mention yesterday also when I was responding or putting a query to yesterday's panel, is that we don't want that narrative to be taken completely towards recovery, while of course we have got to be mindful of recovery. At the end of the day, as a lender, that we have put certain monies out, and there are financial creditors, there are operational creditors, there are crown debts that are due out of failed firm. And while attempting a resolution, we cannot lose sight of recovery. But then I would like to make it very clear that from a policy perspective, all of us very, very clearly understand, as the Lenders Forum, that resolution is the primary objective of a legislation like IBC. So I don't think that there is any moving away from that particular point, and we will stay the course on those lines, despite the criticism either which way, that either we are being pushed more towards recovery or we are being just mindful of resolution, disregarding the recovery percentage. So that is something I think I would like to reiterate. And just to, very quickly to add one more thought to it, is that my request to the rest of the ecosystem players, including the media, is that if this pen or this phone, is damaged and no longer useful to me and consuming a lot of maintenance cost, then I put it on sale. That I might have probably acquired this for $100 or a lakh of rupees. Ultimately, when it is when it is no longer being useful, when it has stopped or when it's a failed device, I put it on sale. The money that I will realize will be purely on the basis of the demand that it can generate. So that is why you have a transparent mechanism where an expression of interest is run, even as part of the NCLT process. And it can go only to the highest bidder. If the highest bidder is going to offer only 10 cents, we can't be looking at the 90. We have to look at these 10 cents that may come to me, number one, instead of this device being completely written off by way of a liquidation, accept the 10 cents. Is that sensible? Or keep worrying about that 90 cents that I'm losing and then keep on holding on to this and then throwing good money after bad money. That is where the lenders do take a call in terms of, we do run a transparent process as everyone follows, and then it goes to the highest bidder. So my request is that if you start building narrative towards the haircut, then it is likely that the lenders may not take any decision. And in that case, you will have a paralysis and then units will go into liquidation. And the entire objective of a legislation like IBC towards resolving corporate stress in an orderly manner will get defeated. So that's my
right.
submission.
So as I hear you, what you're really saying is this: that this is more a matter of a perspective or a narrative that operates in the market, but that is distant from the reality. In reality, what you're really looking at is a resolution, and recovery is incidental. And of course, you can't lose sight of the recovery, because that, of course, is an obligation that you have to your shareholders and stakeholders. I don't think there is any quarrel with that proposition, or that is really the criticism. But some things that we observe while sitting as an observer on the COC or advising some of the stakeholders is that there isn't adequate attention or insight applied on the other dimensions of the resolution plan. I mean, the dimensions other than the financial aspects of it. How will you turn around? Who will you bring in? What is the expertise of these people? What are your projections for the plan? Would you really be able to service the debt to your incoming lenders, even if you are exiting? Would you still continue to be a relevant player in the market? Or would you be able to sustain all this? I think those questions, as we don't see really coming in from the lenders. I think the perspective is also because of that reason, because optically, we don't really see that happen. Even though it might be being discussed back home in your offices, but we don't see that discussion taking place adequately in this use.
Absolutely, very fair point. I think it's also as an industry, we also must bring this into public domain. Some of what happens is that we are a little cagey about being open on certain things, but the evaluation metrics that are formed for evaluating the success, the potential resolution applicants, is a rigorous process, and that is run over multiple meetings of the COC along with the process advisor and the RP. And this metrics has substantial weightage towards the relevant experience of the PRAs in terms of whether their ability for the particular type of industry or activity and the time and bandwidth and money that they are willing to commit for preservation and nurturing and bouncing back this enterprise back to normalcy. And also their prior experience in terms of such turnarounds which they would have probably done. These all has got a substantial weightage, while financial also has certain weightage. I would say roughly about on a 70 to 30 is the kind of a ratio that we apply in any evaluation matrix in terms of evolving the suitability of, or I would say validating the suitability of the PRAs to the plan. And as well taking into account the financial consideration, and 70% goes towards determining what will be, to what extent the enterprise will be preserved. what extent employment can be saved, to what extent this industry can be revived, because sometimes these can be very significant players in the industry, contributing to a substantial portion of that particular industrial activity or contribution to the economy. As lenders, we are certainly interested in preservation of this enterprise. So absolutely, as you rightly said, probably the evaluation matrix that happens in the COCs also have got to some extent, we must make it public to the extent that it does not impede the work internally. I think we must do that so that the people do understand as to why a particular plan was chosen, although financially it doesn't look very lucrative. And one more point, just with your permission, if I can add, it was also mentioned by Mr. Shriram yesterday, is also that the immediate cash recovery is one part. That is what generally gets publicized. But there are also deferred instruments, equity stakes that are being assumed, so that in the long run, if there is going to be an upside, the lenders also can be part of that. The other stakeholders can be part of that. Even they are also being considered. So we should not be guided purely by the immediate financial gains that occur, while of course that is what assumes overwhelmingly a larger space in the media, but that is not true. That still forms part of the whole process.
Right.
I would like to add one point here. When we say that this has become a recovery process and it has lost its importance as a resolution, I don't think that's the right way of looking at it. Because when we came out with the code, it was mainly to bring the debtors to come and pay their debt. So when they are paying it, it's a kind of recovery. We are not pressing for recovery, but ultimately the aim is to recover the debt or NPAs or the money.
Percent or 60% is largely dependent on the valuations, and I think this is something which I want to come both to ma'am, you and Dr. Sani, and of course Ms. Swaminathan and Mr. Souza, please you also feel free to reflect on this based on what your experience on US is. But let me just please phrase my question for the benefit of your response. We all know that in the last 6 months or so, or perhaps a little longer than that, the issue of valuation has become contentious. Without naming a particular case or two, which caught a bit of a headline because of the huge amount of sacrifices the bank took, the matter even went on the floor of the parliament, and concerns were expressed by the members of the parliament, and in the report of the standing committee, that has been discussed, and we certainly see that there is also in the courts, we see the NCLTs actually asking questions about the valuations. Now, this creates a paradox for the banks because they want a resolution. They know this is the value. There is a valuation system. You bring a valuation report based on that. This is what is being offered. They are really commercially best suited to decide that this is the best way to get exit. You won't get better than this. And yet, then they are often criticized for having really let go at a huge discount. Now, this really has created a bit of a debate and controversies, and is really, even we've heard that the parliament may actually even contemplate saying this is the threshold of the sacrifices that you can make as a plan. Now, that would be unprecedented, and nowhere else in the world, at least I'm familiar with, that is done. And I think that would be a huge setback to the very character, very fabric of the IBC law. But that
to conduct the valuation as per the internationally accepted valuation standards or as per the valuation standards issued by the registered valuer organizations. So the rule is very clear. They have to conduct that. Whether they are conducting the reports as per the internationally accepted valuation standards or not, that is a question of the review. So presently, of course, the RVOs, that is registered valuer organizations, are conducting peer reviews for that. But whether that is sufficient, because again, of course, many people are sitting, MDs of IPs are sitting, and maybe many registered valuers are sitting here. So whether any further check is required on the valuers. But keeping in view the quality and quality of the report specifically, I am of the view that yes, there should be a check, there should be proper review of the valuation reports, and maybe in future an organization or an authority like NAFRA may be required for the registered valuers also, because that is the utmost important. Bankers rely on the valuation reports also, maybe fair value or maybe liquidation value, whatever is there. Because the resolution plan, or if the committee of creditors decides to put it to the liquidation, all depends upon the report of the valuation, and of course if the difference is there, and whether the third valuation report is required or not. So all depends upon the quality of the reports. Now coming on the confidentiality. Now how to keep the report confidential? Of course the insolvency professional appoints 2 registered valuers and he gets the report. And it is discussed, and that leakage, basically the leakage of the information about the value of the report. So how to keep that confidential? One thing can be that both the reports of the valuers can be kept in the sealed cover and should be opened only after receiving the resolution plans and opening of the resolution plan. Before that, nobody should know that what is the value which has been indicated by both the valuers. There may be a question that in case of the difference of the opinion, what about the third valuation report? The things may be delayed. So there may be 15 days, 10, 15 days, because valuers generally submit the report. Nowadays, we all talk about the artificial intelligence, and even if the physical visit is required, maybe 15, 20 days delay. But at least we will ensure that, yes, report is confidential and nobody is privy to know or what is the fair value or what is the liquidation value. Now, coming on the basically, because Mr. Batra asked me to touch upon the capacity building of the valuers and, of course, the ethics parts. Of course, IBBI has been organizing various seminars and conferences to build the capacity of the registered valuers, and all the RVOs are also very active in organizing the programs for their basically the capacity of the registered valuers. So these are the things, Mr. Batra. Thank you.
And before, I'd certainly like your comment on it, because I understand the dilemma that you face while sitting on the bench, looking at a larger stakeholder constituency than just one stakeholder, and also a degree of public interest, because at the end of the day, when you're talking of sacrifices by publicity banks, that's a dimension that you can't ignore. Do you face this dilemma, that how do you do it? Because commercially, yes, is well held that it is the prerogative of the COC, but then you feel that it strikes your conscience sitting on the bench that, oh, it's terribly low and we need to question. I mean, how do you think? I know that you'll find it difficult to share, because how your mind works as a judge is something which, of course, it depends on case to case, but we would like to benefit from how you perceive things.
Very rightly said that valuation is one of the very critical point when we decide the resolution plans. Now, at certain level, if you see, the code very specifically prescribes that if the COC, and which is also upheld by the Honorable Supreme Court, that COC is the supreme, and the wisdom of COC or the decision taken by COC should not be interfered unless something very illegal is found or somebody is pointing it out. So knowing that, or maybe having a consciously sensed that there is a much more scope for better valuation, looking at the properties, the prime areas, still there are certain parameters which are laid down that if the plan is above the valuation of the liquidation value, then by and large the COC goes for it and approves it. Now when it comes to us, it's only approved by the COC who are the stakeholders, and as very rightly said by Mr. Swaminathan, that instead of not getting anything or waiting till the property gets diminished, we are interested in at least getting something. So same thing, it comes to our mind that if something more is given in the liquidation, better than the liquidation value, and if the COC is of the opinion that something can be done, or maybe the business can be revived, then in that case we have to, because otherwise beyond the scope of the code and provisions of the code, we do not have much power in questioning it. Though in few cases, some of the benches, the plans are sent back. They were being sent back, and for reconsideration, maybe considering a better value or maybe floating EOI again to get a better opportunity for the resolution applicants or better perspectives. But now I think Supreme Court has, Mr. Batra will agree that has come down heavily that after the resolution plan is approved by COC, even COC, for a reason of getting maximization value, cannot relook at it anymore. So the jurisdiction is very limited to us.
True. At the same point of time, ma'am, I think, of course, we all know that Supreme Court decided 2 years ago that COC is supreme. The NCLT can't go into it, and there are a number of judgments on that. But lately, one case has actually gone to the Supreme Court where the Honorable Appellate Tribunal has held that the NCLT is not just a rubber stamp. That is not what those judgments need to be read into. NCLT can ask questions. Of course, you can ask questions on the implementability of those plans, because that section 31 very clearly gives you that jurisdiction. But that observation was challenged before the Honorable Supreme Court, and the Honorable Supreme Court has actually said that we would like to consider this issue, whether NCLT is just a rubber stamp or whether on the issues of valuations in particular, can they relocate it? And of course, that issue comes from the fact that last 6 months we've seen a bit of a
Yes.
debate, and that matter is now listed for arguments on 5th of May. Incidentally, I'll have the opportunity to assist the Honorable Supreme Court on that. So let's see how the Honorable Supreme Court responds to that. Yeah.
Because one or two matters where the resolution plan was rejected only on this ground, that the valuation is very low and we don't understand how COC has approved it. So it was sent back for relooking it, and that was challenged, and that is now being considered. Because if at one stage you say that there's a maximization of value, that is the intent of the code. At the other end, you say that, okay, whatever price it comes, and if there are ready resolution applicants who are giving better price and ready to deposit the money, then is it required that we have to relook into it and consider this particular point by giving more opportunity, or we have to simply abide by the provisions of the code? So this is the question which is...
Mr. Sir, would you like to share your experience on how does it work under Chapter 11? Do the courts really venture into and go into these issues of what the commercial value is, how the stakeholders are being treated, as long as the legal compliances are in place?
Yeah, so I think, based on my experience and in the US Chapter 11, valuation can be incredibly controversial. And the courts, I think, do tend to get a little bit more into it because under our system, we can have competing valuations. So we can have the debtor submit a valuation and we can have the creditors committee submit a competing one. And so we've really, I think, struggled because it's a lot of burden on the courts, and the courts themselves, even though there are formulas they can apply, there's often good reason to deviate from that formula. I think, especially when you're hearing from experts on multiple sides about this is how we got to point A or point B. And so I think it places kind of a ton of work on the courts. Our Supreme Court has on occasion waded into this, and nobody's ever very happy with what they do in terms of the standards that they try to set. I think because they feel that the bankruptcy bar sort of feels like our Supreme Court doesn't understand the nuances involved in evaluation. And so I think, from our end, I think we share a value maximization principle, but we also share that struggle of sort of how we attain that. And in some sense, the job of the court is significantly complicated by the fact that you have these valuations from experts on all sides.
Right. Well, thank you. Mr. Raman, I definitely would like your response to this, but if you could just hold in for a few seconds, because and dovetail your response into another connected issue with evaluation, which I think has a great bearing, which is preserving the value of the enterprise during the CIRP period. Because the valuers would often do the evaluation based on the asset value as on insolvency commencement date. Which is quite strange, because the fact is that you may have had 330 days plus passed, and the valuation may have significantly varied from the time or the date or the cutoff date on which the valuation is done. Nobody has really looked into this, and this is something which the IBBA really needs to take it up on priority. Because in those 1.5 to 2 years, significant events might really impact the valuation significantly. And then that is left for the banks to take into consideration. But then, unfortunately, you compare that decision with the valuation report, which are maybe dated. And events, and therefore, I think that is something which we really also need to look into it. But before I amplify that point, I just wanted to sort of reflect my view on what we just discussed on the valuations. I completely agree with Dr. Saini that valuation, quality of valuations is something which we really need to work on. If we just start putting an embargo on the banks that this is what you can, this you cannot do with the valuation, that will be barking the wrong tree. And I think that that would really be tinkering with the very fundamental objective of the IBC and diluting the whole concept of COC supremacy, which I think is very dangerous. I understand the concern of the parliament because in their supreme, you can't question it. But they just express a view and ask the executive to find a solution. They don't dictate. But the executive doesn't really have to really sign on dotted lines. They have to come out with an innovative solution to satisfy the parliament that this is the best way of doing it. And the best way of doing it is not to tell the bankers, no, you can't take this much of haircut. You have to take this much only. That I don't think is really the solution. The solution is, as Dr. Zani was rightly mentioning, improve the credibility of the valuation reports, so stakeholder confidence in that. Integrity also. I mean, I think the word integrity is very important. I mean, that's as important for the insolvency professional as the valuers, because you can keep it in sealed cover, it doesn't matter, but the fact is that the valuers know it and they know the numbers, they can pass it on, right? So that may just be, again, an optical confidence building measure that it is in sealed cover. But the fact is that those who know it will pass it on, right? And there are various ways of passing it on. And we know that it is passed on. We know how the market functions. So I think we need to improve the credibility ethics of the professionals so that they understand how important the confidentiality of their work is and how it is linked with their own reputation in the long term. And how should they guard their reputation dearly. And of course, IBBA keeps a hawk's eye on that and questions it in the event there is even an iota of doubt that it has leaked from their desk. But that's okay. Now, just coming back to the issue of valuation, the preservation, while it's easier said than done, how do you preserve the value during this? So because it is the obligation of the IP, which is a statutory obligation. He has to preserve. The word used in the statute is that he has to preserve the value, not only protect. Now, how do you, protection is fine. I mean, I go and put guards. I mean, that's a myth. That's a myth. You put a guard, but protection is tangible, intangible, both. Preservation is the most important thing because that's where you need money. You may need to bring in bank guarantees. You may need to pay certain vendors. You may need to do a whole series of things in order to preserve the value, for which you need money. And money during the CRP can only come by way of interim finance. And that continues to elude. It is completely elusive. We can't see this happening even after 5 years. Why? Why have we not developed the market for interim finance in this country? And this is where, I mean, maybe I'll come to you first on this, Dr. Saman, because you are both the consumer of interim finance sitting in the COC, but also the provider of these interim finance as a banker, right? In a different avatar. What do you think? And of course, you can probably link it with the valuation issue as well when you're reflecting.
Valuers are also here as part of the audience. But for the rest of the people, I would like to put some context to it. See, valuation, I think, as all of us understand, is a subjective matter. It cannot be completely driven by mathematics. It's a certain amount of discretion is involved, and the valuer is expected to exercise his best discretion in terms of expressing its value. So since it is being judgmental, it is likely that your judgment may be different from that of mine. So we have to accept that fact that if I put two valuers, that expecting both of them to come with identical number is impossible. Okay, so we have got to, and same thing applies to the IP, same thing applies to the bench, same thing applies to the lenders. Each of us have a right to have the views. Trying to bring a consensus value to this is not something which we can do. So the point number one that we will have to understand is that valuation is subjective. Number one. Number two, In any valuations, there is a market value, there is a realizable value, there is a distress sale value, and there is also a net present value of what you can generate out of a particular asset. These are all certain numbers we are mindful of. Generally, where people get really carried away is what the market value that as we see. When an asset comes to sale, it is not the same as when an asset is on a going concern basis, kept very nicely, as Mr. Batra mentioned, preserved very nicely, maintained. It may fetch as a going concern something, but then when it is not operational, the plant is shut down for the last 2 years, the valuation was taken at certain point in time. Today, the bidders are looking at and then putting their plans. Whether it will remain the same is anybody's guess. And it will vary from case to case. There is no fixed formula that will depreciate at 10% every year or it will appreciate at 5% every year. We can't put any definitive formula to that. So we need to be mindful of these various components or the elements of even a valuation report. The third, of course, a lot was said about the confidentiality. Even agreeing to an extent that the valuers maintain the highest ethical standards. And oftentimes, in some of these cases, even some of these couple of celebrity cases, as we call, which gets debated in the media, on the floor of the parliament, or maybe in IVBI, in various forums, if you really look at it, valuations were done, resolution plans were received, they were opened, and it was found that the resolution plans were way below the liquidation value. Then the COC, in its effort to maximize the value, gives further opportunity to the potential resolution applicants. 1 round, 2 rounds, 3 rounds, we provide some time because we don't want to be doing either or, either we can accept that plan and be subject to criticism that, you accepted a plan which is way below the liquidation value. As I said in my initial remarks, it's what the other person, the buyer, perceives as the value. That is what ultimately going to determine, because that's the money he will put on the table. I may keep a valuation report worth 100 crores, but then if there are no buyers at 100 crores, what do? I have two options. Either accept that 50 crore offer and go ahead and be subject to yourself to a criticism, or reject all the offer, go into a liquidation, really test whether this 100 crore is realizable. And then it involves certain time and effort and further money to realize that. So ultimately, 2 years down the line, what I would realize probably is in the future. I'm not really sure. I may get 100, may get more, may get less, or I may be spending some more money in preserving the value of this with a hope that I will get this 100. I may not get also, right? So these are the kind of nuances that play out. So it is very easy to say that, of course, even the Honorable Bench has observed, how is this resolution value finally accepted is so close to the liquidation value? It's because if you go back in history, actual resolution plans which came in that case was way below the liquidation value. And 3 rounds were given, and finally, because by then the liquidation value is in public domain. Obviously, finally, as a buyer, this is like a Karol Bagh buying, you keep negotiating, you never know where you end up. Okay, so I'm sorry, I shouldn't have taken this much of time on valuation.
I think
but
you make
thought,
very important points.
taking into consideration of various aspects that was
And
said,
the interim finance.
as to the dilemma that we face in COC is what I was trying to express. And it has got to be seen in that context. So if you are able to understand that, I think we will have a better appreciation of why a particular decision was taken. I'm not trying to hold a brief for COC. COC, Dr. Saini mentioned about capacity building of valuers. It's not that capacity building of valuers alone. Even capacity building in COC has got to happen. As together with IVBI, we engage ourselves in even doing capacity building in COC so that their judgmental abilities are better, that they do it in a transparent and clear and consistent manner is what we all aim. And this is an evolving piece. So we will do. Coming to the interim finance, which again plays a very, very critical, as Mr. Batra said, critical piece in terms of preserving value. 2-3 points in terms of, number one, of course, insolvency resolution in itself, as Chair also observed, is a very evolving piece in this country. 5-6 years in a landmark legislation like IBC is very small. Legislation takes years to evolve. And this is a kind of an evolving piece of legislation. So in that, various ecosystem players have to understand their responsibility and deliver. And one such dependency is interim finance on the lenders. Now, if you see it from the prism of lenders, number one, as bankers, we are conservative people. Of course, as a country also, we are conservative country. And as bankers, we are ultra conservative. Now we have put certain money, taken a risk, what we thought is a fair banking risk, and continued to support that company for 5 years, 7 years, or 17 years. And finally, now the company has got into distress. And there is no certainty as to when a resolution could be happening because of the various challenges that we see as the time that gets taken for resolution. So at this point in time, will my boards or credit committees be comfortable, willing to approve or write another check of another 20 crores or 50 crores? Now the question that comes before the credit committees when the IPs make this request and the COC feels that there is a need, but then when they go back to the respective credit committees or boards, the challenge that they face is that, please tell us what is the visibility of resolution, in what time it is likely to be closed out, and what is the likelihood or possible assurance that you can give us that the money that I'm throwing now is not going to just add up to further NPA, instead it will come back to me in a time-bound manner. This particular question, oftentimes we are not in a position to answer very, very confidently. The presenters, as they come to the credit committee, when I sit on the board, I also ask the same question to the presenters who bring this proposal. So this is number one challenge, because there is no timeliness or certainty of the visibility of or visibility of the resolution plan materializing, which only can result in this money coming back. It's a priority debt. Obviously, it will get paid ahead of everybody else. That's the assurance. That's a mitigation that is available. But unless we are in a position to give an assurance in terms of the timeliness of this and adequacy of the resolution happening, this particular area cannot develop. But having said that, as we have always worked on an industry-leading thought leadership position as SBI, after about a couple of years of work with all the stakeholders, IBBI, IBA, I'm glad to say that SBI is the first bank today has put a board-approved interim finance policy in place. So we have now put a matrix in place. A board has approved a policy that if a particular proposal satisfies this criteria, yes, I am willing to take that additional risk. So we have put that. Now do we expect, our expectation is that other banks also will follow. So only one more point that I would like to add is that we also probably have to look into, rather than looking into the same set of lenders who have got their money already stuck, are there any players who can come into in terms of distress asset funding or litigation finance or priority debt funding who may have a much higher risk appetite than a usual commercial bank? Maybe if we can develop that, that can probably develop as an alternative means of interim finance.
You in fact preempted my next question and answered that on the need to develop a distress asset acquisition market, distress asset players market. I would love to discuss that topic, but I think we have 2-3 very other important topics to cover, and I know that we would like to leave some time for you to ask questions. So I'm taking the liberty of moving to the next session, and maybe if a question comes on the valuations or distress asset market, we could probably respond at that point in time, maybe discuss this a little bit further. I want to discuss 2 other issues that continue to bother all the stakeholders significantly, and in a way continue to cause shadow on the whole success story of IBC. The first one is litigation. And the second is avoidance transactions not being adequately addressed. Let me just discuss with the litigation first, and I want to make 2 comments. It's because again, in a rule of law country, in a country any which way which is litigious, in a country where we are argumentative, we don't give in so easily. Litigation is a very normal choice that an average Indian makes if he has access to justice. So it is not surprising that we have applications. 2 is early days. Yes, there are bound to be requirements to clarify. But ma'am, you are probably the one who observes this as closely as anybody else every day. And I'm sure you feel very frustrated when some applications come up which are like disastrously frivolous, which are so ridiculous that you believe that this how could you even as a lawyer file it at times, right? And then of course there are those that you believe that, how can you even decide the matter further unless you decide this issue? And how, directly relevant it is to deciding the resolution plan, or because it goes to the very root of the matter or something like that. But do you really think, and I'm articulating my question that way, because we all know that there are litigations, some justified, some are not justified. Do you think that the IBC is really facing the risk of becoming an adversarial litigation forum? Because that is not what it is meant to be. By sheer nature and definition of IBC, it is a resolution process which you need to resolve across the table. COC is a mechanism, and RP is a mechanism, and you don't go to the court just on a knee-jerk basis or drop of the hat basis. I mean, I think that is the larger risk that we are facing. But your comments on that, please.
This is the first and last question asked to the NCLT members for causing delay. Now, the blame is always put on the tribunals or courts that there is a delay in dispensing justice. I would like to very interestingly quote 2-3 things. Recently, our Honorable Chief Justice of India, in one of the speeches, he has mentioned, in this era of instant noodles, people expect instant justice. But people don't realize that the real justice will be casualty if we strive for instant justice. I think this is self-explanatory. I need not take much of time. You all aware about it. In a democratic country, when there is a statutory right to a party given by the legislation to seek justice of the whatever injustice you are facing or reliefs which you want, can you prima facie on the first stage stop anybody from filing application? That's my question to the probably entire nation. If we say there is a delay because of applications, who is filing applications? It's the people who are filing application. And secondly, we say that they are frivolous. What stage we understand that they are frivolous? Only after adjudication. Unless we address the application, unless we see that prima facie in law, they cannot file application, which are immediately rejected. So it's not that the judges are not aware. Right from the civil courts to the criminal courts, if the application is without any backing of law or not maintainable under law, they are immediately rejected. And in fact, now the trend has started that we put heavy cost in order to discourage such kind of applicants coming and wasting our time. But can you say that by and large, blatantly you can stop bringing applications because we want early resolution? We are resolving an industry which has hundreds of paraphernalia and hundreds of consequential effects on various classes of maybe people, maybe vendors, maybe the creditors, lot of area. It's like you tell a doctor that a chronic disorder or a disease, we will give you 1 month time and you cure it. Can we say that? It's a kind of a disease or a disorder in society. Now, if you go back to the old laws, which were made in 1909 and 1920, almost after 100 years, we have thought of bringing a new code in insolvency regime to bring out certain changes. And within 5 or 7 years, we want to see remarkable changes in spite of accepting that the recovery or the money coming into the economy, the NPS going down, the banks, Mr. Swaminathan also said that we understand that the recovery is much higher. Even the government has recognized it. So we cannot say that overnight it will happen. And if we are sitting there in the bench for doing justice without hearing the other side, because there are times when we hear the applicant, senior counsel completely and we are almost deciding the matter in their favor, but when we see or hear the other side, when we see the documents, it changes the perspective. There are a lot of social factors which are there. There are a lot of parties which are there, which are affected. You can't ignore them. It's not that, okay, you have not paid the debt, this is a stick, Either you pay it or you are debarred from taking management or you are put in jail. We are not for that. And insolvency is not an offense. We have to understand one thing. It's not an offense. If we want to cure, it's a financial crisis or probably financial disorder. And any disorder, when it comes to our life, or when we recognize that there is a disorder, by the time it has got long based roots. So to cut the root immediately and bring the justice instant, it's not possible. In fact, in one of the speeches, the Attorney General, Mr. Venugopal, has said that out of 24,000 judicial posts, 5,000 judicial posts are vacant. So again, the question is that, is the judges are incapable of giving justice, or are they delaying? My question is to the people. Those who say that there is a delay, of course, the court for the first time has come out with a timeline to decide certain process. Court has never said that you decide application in 5 days. It can't be done, and nobody can do that. If you want to do justice, you cannot have a timeline. Only thing is that we have to educate people not to come with the frivolous applications. The trend has already started. We are putting heavy cost when some frivolous applications come. We debar them from coming again. So strictures are passed. It's not that the measures are not taken. And I'm sure that no judge would like to delay it. Plus, we cannot always think that Western countries this happens, in the other countries this happens. We cannot compare because they are totally different countries. One religion, one language countries will not face the problems which we are facing in India. At different states, you will have different language problems. Even the members, when they are transferred in a different court, the member going from Chandigarh to Chennai will have difficulty in going through the papers. How do you expect the instant justice or instant resolution? So all these factors we have to consider, and I would rather suggest at this panel and to all those who are present here that we always cannot compare that anything with the Western countries or anything with the other countries, because India is multi-regional, multilingual, multi-geographical dimension, the multi-religious countries, and a truly democratic country where every citizen needs to be heard. So in that country, you can't have anything instant.
Right.
Moreover, rightly, I would like to again quote our Honorable Prime Minister Modi ji in recent conference of all the chief ministers and
Chief
yes,
Justice.
Chief Justice, he has very rightly mentioned, basis of Swaraj in any country is justice. Until basis of justice is not understood by common men, it will not be of any use. So we have to decide, do we want to show the figures that in this years we have recovered this much, we have resolved this much, and those resolutions then go in appeal and stand in Supreme Court? Or do we want to take some more time and go to the root cause, address the common persons? In fact, here, this is a forum where I would like to say that we have still not touched the issues faced by the operational creditors, who are totally neglected and not paid even a single paisa in all these recoveries. The traders, vendors, day-to-day suppliers, the partnership firms, the individuals, those who are insolvent, they are there already in existence. We have not even thought about them. So we can't hurry up like that.
You're right, ma'am. I mean, I understand what you're saying.
Yes,
I
I
know.
take your permission for only about 2 minutes.
Only
Of course,
2 minutes.
doing a
2
rejoinder
minutes,
to the chair.
2 minutes.
Yes,
2
exactly.
minutes.
But doing a rejoinder may result in contempt, but then being a fellow panel member, I think I'll be given immunity. So
But
it's not my...
more than 2 minutes. Mr.
Only 2 minutes.
Yeah.
I think I just want to put the context is again in one is the delay part, another is the forum shopping. So what we are genuinely worried about, ma'am, is the forum shopping that people do. And we know that this legislation has a clear NCLT, NCLAT and a Supreme Court structure. And as we sit in this noble state, so we know that the high courts here do entertain petitions which would like to stall the proceedings in the NCLT. And even today there are cases that are pending. So and then there are cases which are pending for admission 3 to 4 years as on date. These are some unique cases, but people have used all possible forums available at their disposal to delay even the admission itself. While of course we are mindful of the pressure under which the judiciary is working, given all the limitations, the only worry is the forum shopping has got to be stopped somewhere so that people are not allowed to litigate on the same issue multiple times in multiple forms.
Right.
That's the only
I mean,
submission.
I
that
think
would-
that's a point well taken. At the same point of time, my view is that forum shopping is an aberration. I don't think that's a norm. Only a handful of those resourceful people who can afford to hire lawyers and go litigating elsewhere, they do it and they will continue to do it. You can't stop them. I mean, that's the historical aspect. But yes, I mean, I think the focus, as I hear both the Dr. Deepthi Mukesh and Mr. Swaminathan, is that you can't stop people from going to NCLT. You can't curb their rights. You can impose costs and deter frivolous litigation. You can report those cases widely so that people know that there is a consequence of filing a frivolous litigation. But we need to find something else as a solution to reduce the workload. One is, of course, appointing more members, but that still may not be adequate enough. Because there are so many issues, then you have to provide infrastructure, then you have to provide so many things. There are challenges. Mediation is one important aspect, which I believe may be a very important tool to reduce the workload, where some of the issues which are really sparked on the sides go on the mediation, come back after 20 days, 30 days, 50 days. And I'm sure IBB is doing this as a subject for standalone discussion. I don't want to take it up now because then we will lose the time to discuss some of the other topics, one of which I want to discuss before we open it for question and answer session, and that also only for the next 4 minutes. Because something which I've probably taken the liberty of mentioning, because this is something which we face every day, is avoidance applications. We all know that we haven't really had many adjudications and avoidance applications. And I won't really blame NCLTs for that at all, because they have to prioritize other matters. Avoidance can be dealing from the resolution plan. But the fact is that should we have an alternate mechanism for this? Should we have special courts, special benches? Because this often may require even cross-examinations, because you are really, the consequences of penalizing somebody, clawback, huge amounts of money can't only be done by way of a simple order. It'll keep going in appeal and get tested at the Supreme Court at some point in time. We haven't really seen a test case as such so far. But we really need to pay some attention to this aspect. And I request, ma'am, your 2 minutes on this, and maybe Dr. Su, your 2 minutes on this. And of course, we all know that maybe last comments we will probably. Just 2 minutes on this, because I know that
very quickly, I'll say that avoidance applications, the applications filed under 43, 45, 66, fraudulent and avoidance applications are maximum consuming time, because there are number of respondents. Maybe it goes up to 80, 120. So receiving the documents from them, going through the documents, it takes huge time. And what we can do, very rightly Mr. Batra said that ultimately, when it is decided that the avoidance or the fraudulent transactions money which is recovered or which will be recovered will ultimately not affect the resolution. It's a parallel proceedings. Even after liquidation, before dissolution, these applications can be heard. So the money which is coming from these, by passing order in these applications, if it goes to the original stakeholders or the creators' benefit, then side by side these applications, probably we can have a structure where these applications can separately be adjudicated along with the resolution going on, so that resolution doesn't get stalled, and the complaint by the financial creditors that our resolutions are getting delayed probably can be addressed. But some of the claims or some of the issues which needs to be decided first, like constitution of COC or whatever it is, that has to be decided first before the plan. So that is how it goes.
Mr. Su, I mean, I know that US is a very sophisticated, very well-developed market, and but avoidance applications probably don't take as much, because when they get decided, the costs are so high that people don't indulge in that, and I believe they get settled across the table also most of the times before being led to court. Would you like to make a couple of comments on that?
Yeah, so I think that's exactly right. I think a lot of the times you do see settlements just because the cost is so high. And I think part of what we've struggled with in the US, I mean, at least a little bit, is kind of on a similar vein, sort of the extent to which We want to incorporate avoidance actions into the process, how we can decide these issues without sort of delaying the main procedure. And one of the things that we have, I mean, just to tie back into a comment that you made earlier, is, you know, we have started to send a lot of these issues out to mediations. And so thinking about how that can possibly play a role, I think could be something valuable in terms of just thinking about, you know, sort of easing the, you know, the burden on courts and on their dockets, because I know they have our, you know, avoidance actions have the potential to take up a lot of time. And if you can get them into a settlement, whether through mediation or otherwise, you're going to be, I think everyone will agree, you know, eventually that you're going to be better off.
Well, thank you. I mean, my request to IBB, unless of course this is something which is already on their radar, is that to please commission a paper on assignments of avoidance transactions and do an international study on this, because assignment is also something which will take the burden off the lenders, because if they can get an immediate discounted value also, the NPV value of that is quite high. And also the fact is that they can actually, loss of opportunity also is addressed. And then you develop an alternate market for debt trading on that as well. So this is something which also needs to be done, because it will take away the immediate urgency from that, reduce the workload, and also build an opportunity market, an alternate market for more players to come in into the ecosystem of IBC. This needs to be something which I think needs to be there. Now, I know that I got a mic at 9:35, not at 9:30. So, you know, I would still, you know, take the liberty of asking a few more questions than what normally would leave for a panel. Let's just have another 20 minutes of Q&As. And of course, in that, we will make our comments as well, so that we are not just responding to what we think are the issues, but also have the opportunity to reflect on what you believe as market players that you would like to hear from such an esteemed panel that you have here.
Before we start, then lastly, I would like to say one line that companies' mediation and conciliation rules provides for such kind of a panel. The regional director under MCA has started taking steps, and the Honorable President, Mr. Ramalingan, Justice Ramalingan, in the one of the colloquiums has said that this will be a priority. We will be looking into it. We will be going for it, as well as we are going to take help of the artificial intelligence in order to decrease the delay and simplify more process. Where it can be done by artificial intelligence, we judges need not spend our time, so that we can give more time in disposing of the applications and dispensing justice.
And also, since that colloquium, the cause list has been restructured, and now the fresh admission cases are listed first, then resolution plan approval applications are taken up, and then miscellaneous are taken up. That practice has started in the last 3-4 weeks, which is also helping the moves think faster. Now, I mean, I don't know who is going to be coordinating who gets first, or do I have the liberty of deciding who raised the hand first? Please introduce yourself very quickly, and keep the please question, no comment for the time being, right? So please, and make the question also very crisp, short, so that, you know, please. Thank you.
Sure, thank you so much. My name is Vikash Goel. I'm a registered valuer, also a PhD research scholar from Kolkata. So one of the things we spoke about valuation as one of the important areas. From an operational standpoint, a registered valuer scope is defined by the resolution professional. And in majority of the cases, the resolution professionals do not ask us to value the enterprise. So the scope is limited to only identifying the fair value and the liquidation value of the assets which are already there in the balance sheet. Is there a view that we should also consider calculating the enterprise value, so that at least the intangibles can be taken into account? What happens if the resolution plan is already there in place? So there's no one doing that at the moment.
Dr. Sani, would you like to take that?
Right now, I don't think this is the thing. But as the valuation is actually done as the fair value or the liquidation value. But if suggestion is there, that can be actually given to the Ministry of Corporate.
My personal view on this is there is nothing that stops you from doing the evaluation, because when you do the assets, you do include in that tangible and intangible both, and the sum of that is the value of the enterprise, in my view. There's nothing that stops. In fact, there's no bar, and also I think you need to read it in a way where you are ultimately giving a value which is a net value broken into asset value, tangible and intangible. And therefore, that is an innovation that the industry needs to bring forward and do it. I mean, I don't really see that how that is a restraint at the moment. At least that's in my perspective. Yeah, please. We'll allow you another question later on, please, but because there's so many hands up. There's a gentleman here. Just one second. The gentleman here. Inko dijiye, please. Gentleman in the front, if you don't mind.
I'm D. Roy Chaudhary, I'm MD of NESL-IU. So I have 2 questions. The real test of recovery versus resolution for a banker is whether the existing bankers continue as part of the resolution plan. It has happened in a few cases where existing bankers continue to lend the new entity. But it is generally an exception, not the rule. Most of the time, the existing bankers exit. So if the existing bankers stay on, existing COCs stay on, so there's a scope for them to, have some benefit from the upside in the firm when the firm recovers.
I don't know if that is a question, but that's on a case-to-case basis. I mean, you can't generalize that as a rule. I mean, it'll depend on whether there's a trust deficit with the management, whether they really see potential in they see that sector going forward or not. That's an individual decision of that particular lender is how I believe it. I mean, can you generalize it in that sense?
No, I think it's well responded. See, essentially, the source of finance has got to be arranged by the successful resolution applicant. It's ultimately his choice. So I'm sure that he will be approaching the lenders. He may as well approach the existing lenders, or he can approach anyone else also, depending on his own banking choice. So we can't generalize that existing lenders should participate. The second is that your objective of that proposition is that whether bankers can be participating in the upside. The answer is no, because that will be a completely new lending relationship. Under new terms and conditions, those credit facilities will be extended. So if there is going to be enterprise doing very well, I'm not going to have a right of recompense of what I lost in the previous resolution. I will get my new money back with whatever new terms and conditions. But the successful resolution applicant is not going to give me anything extra for what I lost in the earlier one. It's not like a right of recompense that available in a restructuring. That's so true. It's not going to help us even if achieved.
Okay, Jans, one question here. Aapke liye, please. And then we'll go another question. Okay, I'll come to you after this, please. And the second mic can go there, please.
Yeah, good morning. And my question is to Honorable Member NCLT. This is regarding admission of CIRPs. So as we have already discussed, a lot of delay here. So basically the admission required to be only 3 aspects. It's a fact-driven kind of a thing where you have to just check on 3 things: debt, default, and limitation. And you also said that you will be using artificial intelligence very shortly. And now there is a provision for IU certificate for default. So I want your opinion that can we cut down this delays, because this leads to a loss of value because of delays, as sir said, almost 2 years, 3 years in admission. So can we handle this delay?
Very quickly, I'll say that the major cause may be pandemic. I'm sure that this is not because of the delay at the level of NCLT. Probably prior to pandemic, we did not hear about such delay of 2 years of admission. Number 2, if the applicant is not vigilant enough, sometimes it happens that applicants don't appear. 3 days, 4 days, and then ultimately we have to dismiss it, then come and revive it. So the entire process, nobody sees that how the matter is moved. Number 3, I would say that debt and default, yes. But if the notice is issued, the other side has to be given chance of hearing. Because in hurrying up, we should not lose any genuine person to right to hearing. So when we are doing justice, we need to see that certain laws of natural justice and equity has to be followed. And number 4, there may be few cases where the applications have been delayed for such a long period. But again, the inflow of filing of applications is such a huge, like in Bombay and Delhi, in spite of having 5 and 6 benches per day. If you have 100 applications, how many can be listed? So there is a delay in listing application because of the huge inflow, and the resources available for addressing those applications is very less. One member taking 2 benches, 3 benches. So again, how much you can attend? It's not that it's deliberately done or it is done because of some infrastructure problem, but these are the practical problems. Mainly, this is because of the pandemic, it might have happened because there are a lot of other issues at the NCLT level which we need to address, infrastructure and the other things which the Honorable President is very seriously looking after, and he is very much into removing all the obstacles which are coming in way of the fast disposals.
Right. Yes,
So I can assure.
And I think the results are quite visible and obvious in the last 30 days. We've seen there is a sea change. I mean, we can sense it. We go to court every day and we can sense it. The gentleman at the back, no, just the one who has the mic. Yes, please ask. Yes.
Good morning, sir. So I am Ishan Japuryar. I am a final year GIP student. My question is to the Honorable Judicial Member. Ma'am, so from the data that we have sourced from IBBI, it appears that the average time taken for admissions is around
So that question
200
has been asked
So,
already.
sir,
Please don't repeat the question. No? If there's anything else, please ask about it.
No, so my just prima facie question was, is passing ex parte orders and allowing like a limited time frame that only for the initial 30 days objections to the admissions or to the approval of resolution plan
That
can
is
be done?
done. That
Could,
is-
could that be
that-
done
that
as
is
a quick
done.
suggestion?
That is done.
is done, yeah.
In my court, not more than 3 chances.
That is
In
done.
any application, in any matter, anywhere.
Just
Third
just-
chance,
no,
right to
just
file
one
reply closed, matter closed, ex parte orders passed.
I
Then
need to
they
come
come and challenge. Then revive it. Either they go to appeal, get it revived, then they come back. So that can't be stopped.
Yes.
It is the people who have to think that they should not come in such a litigative manner
Right.
if they want resolution.
All right, please.
Yes, good morning, and first of all, thanks for the wonderful session. A quick point to Honorable NCLT member in respect of unburdening judiciary. So, quick thoughts, if you could express your opinion. One is that could the procedural matters be delegated to the registrar level rather than coming to the judicial level? And the second, since IP, insolvency professional, is a officer of the court, can some work to make prima facie opinion or first level of scrutiny can be delegated to IPs? Any scope and the future direction on that?
Regarding the procedural part, it cannot be delegated because whatever is done at the registrar level, like filing of the pleadings and completing of the pleadings, at certain level when there is a huge delay, it's been done. With the artificial intelligence, we will be able to cure it probably another in few months. But where the judicious application of mind is required, whether such right can be availed, like for filing additional document or filing any IA, that right has to be given to a judge. That cannot be delegated. So under law. And number 2, the IPs, they are already officers of the court. At many level, they do a lot of work of scrutinizing, like admission of the claim, then verifying the claim, and all that has been done. But when the question of law comes, it has to come to the court.
Right. And if I may just add 2 comments. One, to your first question, that in fact is a decision which the central government can take by way of amending the rules if they decide that the law of the country permits that certain function which currently falls within the domain of the judicial bench can be delegated to a registry or not. That's a choice that they have to make. And that too by testing it against the law of the land, as the Honorable Member was saying. And as far as the RP is concerned, again, the same issue. In the personal insolvency, you see that the scheme is that the RP is given the opportunity to report. And that also raises a lot of issues. So I don't know whether that is something which the legislator is willing to do, because they made a conscious choice of not giving that function to the RP in the CRP process, but chose to give that to the RP in the personal insolvency, because the dynamics of the two and the characteristics of the two are very different. And it's also to provide access and speed. So these are the aspects, but I don't know how feasible it is for that. But yes, I mean, there are policymakers in this room who are listening. It is for them to relate to the right forum. Yes, please. Yes, the lady. Yes.
Since we know that the valuations are not up to the mark, we are receiving the valuations very low, or either the resolution plans are very near about the valuation. So should we share the valuation with the COC and let's have the discussion on it? Make it a public, instead of like we know that sometimes the resolution plans are very near to that valuation. Somebody is able to know that valuation or through how about sharing that valuation with the COC during the process?
No,
Transparency in the process.
yeah. See, but I no. Again, from a objective purpose, as you look at it, is that going to resolve the issue of controversies that typically surround valuation? My sense is that no. Whether you share it with COC, don't share it with COC. Even the couple of cases which became so much controversial. If you have seen that, it's at a stage where the COC came to knowledge, and thereafter plans got improvised. So I don't think it's going to remove. What will probably help is, one is in terms of, as Dr. Saini suggested, a kind of a better template for the valuers to demonstrate, and a skill building for them to make a fair valuation of their task, and then maintaining a confidentiality as required. Certainly these matters require confidentiality, because we don't want the potential resolution applicants to be guided by the valuation that is available. While of course a decision will take both into account, but we would like these two to be segregated as much as possible. So making it public, if something has got to be a secret, that has got to remain with me. The moment I share with the second person, it is no longer a secret. So sharing it COC, I don't think will remove the difficulties that we are currently facing surrounding valuations. The third and most important factor, which again I would like to reiterate, is resolution plan being around the valuation should not be as much of a surprise to all of us. If, as again giving the example of the fair value of this is 20 rupees, I'm sure anybody who is wanting to buy also will quote 18 rupees or 22 rupees. We can't expect that the potential or probable value of this is 20, but somebody will come at 40. Unless the valuer has done a serious error in terms of putting 20 rupees to it. So the resolution plans will surround valuation, because potential resolution applicants also will have their due diligence and valuation mechanisms.
I'll take four more questions. Just one second. I'll have to give to maybe later on. I'll have to four more questions. I'm just going to come to it. Before that, I just want to make that I'll end this session with each of the member asking each of the member of the panel one reform that they feel is a priority at the moment. Yes. So please think about it. I'll go to that lady first. I mean, I can't not be blamed for not giving equal representation. Yes. Yes, please.
Though this is about the litigation timeline, I have, it's a question basically, but it's a suggestion. When IBC is a time-bound program, the courts cannot work in a timeless manner. In fact, I am a victim of a case where more than 700
Ma'am, please, not
okay.
individual cases.
Okay, sure.
Yes, yeah,
sure.
please, not
Here,
individual.
my suggestion is that the day one hearing case and the day 700 hearing case should not be put together and lose its sanctity. Instead, wherever, based on the timelines, can it be sorted in the court level, so that some timeline, we are conscious of the timeline in hearing the case and
I think we've got
disposing it off.
Yes.
That's it.
Just to summarize that, there is already a listing year-wise. We list all the matters of 2017 first, then 18, then 19. 22 is given the last chance because the pleadings needs to be completed. We are giving not much time to complete the pleadings. Another hurdle which we have faced is that e-court and e-filing. In the year 2019 December and 2020, when the e-filing started, there are a lot of technical issues, and unless both the filings were complete, we could not take up the matter. It was very fortunate that we could do e-filing prior to the pandemic, so that during the pandemic we could have the video conferencing courts and dispose of lot of matters, probably equivalent number of matters, which we could not have done without e-filing. So the government's emphasis on completing e-filing. So there are teething problems are always there in all the systems, in all the law, and misuse of law is nothing new to us. There are some section of people who are going to misuse it, but then we have to have some patience. It is being improvised at every level. The participants and the interested parties are coming up with new ideas, but we have to have some patience. It can't be instant. It can't be fast food.
So, and not on delays, please. I mean, so we've addressed enough on these, please. Yeah.
It is not on delays. I mean, my question is related to the remarks and whatever you mentioned regarding the preservation of the value and erosion of avoiding the erosion of value. This is a practitioner's issue. And I related this to, there was a circular from IBBI which said that the COC members of the COC who present in the meeting need to have the authority to take the decision. In my view, it is not happening. I mean, SBI could be an exception. I have never had any problem with that. This is not really happening because there are occasions when the e-voting time is requested for 7 days and some extensions are requested for another 3-4 days. So it is defeating the purpose. And
I understand that, but I want to discuss larger issues, not these operational issues, because every case will have an operational issue. But I certainly want to take one point from there and mention, and this is for the ears of the IBBI representatives here. The point that I made of erosion of value during the CRP process demands that if the COC and the IP feels that he should carry out a revised valuation to capture the right valuation, that should not be seen as contrary to law, because I'm aware that in certain cases, IBBI thinks that no second valuation cannot be done. And I think the market dynamics would often require that if a passage of time has happened, you revisit the valuation. That can't be seen as a violation of the law. But any which ways, that's the choice that IBBI has to make. Sir, here, one question here, and aap puchiye, please. Aap puchiye, then we'll come here.
Good morning, everyone.
नहीं सर, आप एक मिनट पहले उनके पास माइक है, उसके बाद सर आपके पास आ रहा हूँ मैं.
Good morning, everyone. This side Advocate Dheeraj Garg. Sir, my question is, on the one side, we emphasize on the mediation in the CIRP. On the other side, we try to emphasize that the early CIRP initiated would bring value maximization to the corporate debtor. Don't you think reading mediation and conciliation into CIRP will kill the time for early admissions of the cases, and then another Pandora box of rejections of a mediation process or mediation proposal will increase the burden of the NCLT?
No. According to me, being a trained mediator from Bombay High Court and having done a course and having a diploma, I would say that mediation will not waste time unless the parties want to waste time. Number one. Number two, lot of issues are settled at mediation level because basically nobody wants to litigate. People have now realized that the litigation is a costly affair. It's only for the rich people, not for the small entrepreneurs and the operational creators. So matters get settled, they come across, they come out with the real issues. Whereas when they come in the court, they come with the legal issues or some technical issues. And mediation is always a win-win situation. So whatever is decided in mediation generally doesn't go in challenge. It's an one-time settlement and end of it. Whereas in litigation, whatever order you give, it will go to appeal, no end to it.
Right. Absolutely, and mediations can be invoked at various stages for various issues, not just at the pre-admission stage. And in fact, the Prime Minister said that, in fact, in the first term of this Modi government, and also reiterated later that the future is mediation. And the sophisticated economies around the world, US, UK, Singapore, Australia, all of them use mediation significantly in the insolvency process and successfully. So what is stopping us from doing that? I did hear that there was a move by IBBI at some point in time to set up a committee on this, but I hope that is expedited. And I know this is a stakeholders issue, whether mediation is a corporate affairs issues or a finance ministry issue or a law ministry issue, but I think all of that can be resolved. And maybe Dr. Saini may want to make a comment on this, quick comment.
Yeah, actually this has been discussed, and I think the bill is already there with Ministry of Law, and if something is to be done, that can be done at their level.
All right. So ek sawal, last question.
On the same mediation from the US perspective, what is the scope of work and how do you feel, what is the success ratio? Because, it will, if we implement in the had a lot, discussed a lot, would like to hear from the US perspective about the successful and scope of mediation.
So basically what he's asking was the experience of mediation, success rate in the US.
Yeah, so I actually will be presenting a paper on this afternoon, drawing from some recent US cases. So in general, mediation is viewed very positively in the US. It's very considered very successful. We've hit a few roadblocks, I think, recently because we've had some mass tort cases that have come in where the parties have been a little bit more litigiously minded. There have been more personal feelings than we would tend to see in a corporate case. So that has thrown somewhat of a wrench in, but I think overall, it's been a very positive experience. And so that would be, I mean, going to your last question, that would be
Yes,
the
that's, in
reform
fact,
that I
was
would
going
want to
I'm
see.
going to say that maybe, you know, so I take it that you've already said that mediation is one urgent reform that one would expect.
I do. I think, I mean, obviously I'm a bit of an outsider to the whole process, but given what I've heard and given
No,
what
I would
I've
echo
seen,
it. I would echo it for you.
I
yes.
think it just seems very important, at least as a focus. And I think one of the things that I wanted to, that and I'll discuss further this afternoon, is kind of when you're thinking about mediation, sort of the importance of developing an infrastructure and a framework. Because one of the things I think we've done not so well in the US is kind of, we've done a bit of an ad hoc process. And it's worked out okay, but I think we could do better.
Right. Percent. सर एक परसेंटेज का वो पेपर्स उनका प्रेजेंट कर रही हैं, आप एड्रेस आप उनका सेशन अटेंड करिए. Once anything, I know for you there'll be probably so many because you're an insider, but now you are an outsider, you can say.
Yeah. Since you asked for the reform, only one thing I would like to tell, of course, based on the data, since the voluntary liquidation proceedings are not adversarial proceedings, and of course, with the permission of the ma'am, I would like to share some data. As on 31st March 2022, 644 final reports has been submitted, and out of that, only 320 approximately 50% resolution orders has been only passed, so 50% are pending. And actually there is a process under the Companies Act also, and if assets or liabilities are equal or assets are able to meet the liabilities, then STK2 can be filed and Registrar of Companies can also strike off the company. So likewise, there can be an administrative process for volunteers that will actually reduce the burden of the Honorable NCLT and save the time.
Yeah, I think Dr. Senia, that's again something IBPA should be listening as to whether, you know, we can really tweak the law on that, because this is a subject I know you wanted to discuss, but unfortunately we didn't have the time on our side for that. Ma'am, what is it one thing that you
one line that in the US and Australia, I suppose that before the case goes to the court, a lot of time they send it to the mediation center, it gets settled, and that's how the number of litigation coming to the court is so low, and that is why the disposal is more.
Right.
This is where exactly we have to put our stress on, that if mediation, if we can resolve it, and mediation, whatever resolution or whatever final agreement, consent agreements, it doesn't get challenged.
Right.
So
Right.
there's no.
So my vote is also for the mediation. So there's 3 already out of voluntary liquidation, which also, I mean, you would also have my vote for that also. Swagnathan.
Certainly, of course, my vote is also there for mediation, no issue. But then since we can agree on that point, and
Unanimous.
of course, one, in terms of your question as to one, of course, there are several reforms under discussion, as you know, but then in terms of prioritizing, if I can say, let's make the admission process a lot more objective, give extra wings to the information utilities. If there are going to be prima facie evidence available in terms of the document produced and as available with the information utilities are there, and a default is established, let's make the admission as quick as possible without giving a lot of time being spent on the admission stage. If we could do any kind of change in rules or process which can facilitate that, that will be good. The second request that I can add is, once a resolution plan is approved, the order by an adjudicating authority is something can be a time-bound activity. These are only 2 requests that I can make.
Both the things are being
when
addressed.
the patient is on the table, we don't have a control.
Very well. Very well. Thank you so much. We finished dot on time. I got the mic, as I said, 5 minutes later than the scheduled time. I went it exactly 5 minutes after the scheduled time. Thank you so much for your attention. Thank you so much for your interest. And I have to thank everyone on the panel for their very valuable contribution, comments, and also above all for sticking to the timelines, being very short stripped, and also bearing with me because I was always constantly pressing my phone as an indication, and also constantly bringing my mic more close to my mouth so that they know that I'm wanting them to stop. But thank you so much. I appreciate it very much. And thank you for inviting us. Thank you for inviting me.
Thank you, sir. Thank you, esteemed panel members, for covering a lot of ground and building the narrative on pressing issues, which I'm sure are being discussed by all stakeholders in various forums. May I now request Mr. Amit Pradhan, Executive Director, IBBI, to present a memento to our panel members as a token of our gratitude and appreciation. Sir, I request you to please present the memento to Dr. Deepti Mukesh. Dr. Deepti Mukesh. May I request Professor Laura to kindly accept the memento? May I request Sri Suman Batra to please accept the memento? I request Sri J. Swaminathan to please accept the memento. I request Dr. Navrang Seni to please accept the memento.
At least we can say this was a timely started and timely ended session, no delay.
Thank you, sir. Thank you, ma'am.